And we are live on YouTube, and I'm going to let everybody in. Good evening, everyone. Welcome. This is the Renters Alliance Renter Town Hall. We just opened the doors. We'll get started in a few minutes. Welcome. If you're just joining us, this is the Renters Alliance Renter Town Hall. We've just opened the doors. So give us a couple of minutes and we'll get started. Just another minute. Hang on, folks. We'll get started in just another minute. Waiting for a magic minute or a magic number, whichever I decide. And it's a magic minute. All right. Good evening, everyone. My name is Matt Losack. I'm the co-founder and executive director of the Montgomery County Renters Alliance. I'm here with our staff, our outreach director, David Mullins, our senior outreach coordinator, Jackie Mashinya, our outreach coordinators, Emily Towie, Tim Huang, Pat Beckham, and Hua Ho, who is our service year intern from the Maryland Service Year Program. And of course, our four panelists tonight, who are from the Office of Consumer Protection, the Office of Landlord and Tenant Affairs, Code Enforcement, and the Office of Rent Stabilization. And each of them will introduce themselves as we go. A couple of rules for tonight. If you have individual cases, you can put your information in the chat, but we're not going to discuss individual cases tonight with the people who are on board, though you can ask questions for sure. We ask that all questions be put in the chat. Our staff will be monitoring the chat to make sure that your questions are addressed. We also expect that all questions and comments be civil and respectful so that we can move along and get information from county officials whose offices help enforce renters' rights in Montgomery County. A couple things. I also wanted to tell you that October 8th, and I'll remind you at the end, is our next Renter Town Hall. This one will be a candidates forum. We will be co-hosting with the Montgomery Community Media, a live television broadcast with the candidates for county executive focused exclusively on renters' rights and affordable housing. And we will provide more information on that in our newsletters. And if you're on this town hall, you will get our newsletters. So we're looking forward to that. And I also wanted to make a special announcement that our senior outreach coordinator, Jackie Mashinya, will be leaving us on Friday for a 9-day tour with the Office of Human Rights throughout the South to look at those civil rights areas in the civil rights history of the United States. I was invited. I can't go. I just got back from vacation. My staff won't let me take lunch, much less go away for another 9 days. But we felt it was important to have Renters Alliance representation on this important tour because, as you should all know, the civil rights movement was also very much a part of setting up housing justice in the United States. And so having a voice of the Renters Alliance on that trip, which is run by, again, the Office of Human Rights under James Stowe, is a very important participation for us. Jackie will be sending us dispatches along the way, and we will put that information out in our newsletters and in other kinds of communications. So we look forward to her reporting over the next week. So with that, let me turn it over to one of our outreach coordinators, Emily Towie, to lead us into the first couple of presentations. Emily?
Thanks, Matt. First, I want to introduce our first guest, Sharon Wilkerson, who is the program manager of the Office of Rent Stabilization, which is a relatively new office in Montgomery County. Thank you for being here tonight, Sharon. I know we've had you come in the past, and I'm sure you'll be back again. But would you mind just giving like a brief introduction about yourself, and then we'll jump into the business?
Course. Thank you, Emily. And thank you, Renters Alliance, for having me here this evening. Always a pleasure. As Emily said, I'm the program manager for the Office of Rent Stabilization. I do have a manager, Polina Melvin. She's unable to make it tonight. Typically, we tag team these. But again, so we are fairly new. We're just over a year old. So we are the Office of Rent Stabilization. So we handle everything related to the limited rent increases for specific renters within Montgomery County. So I just have a quick presentation. I know we have a packed agenda, so I will move succinctly. Please allow me to share my screen and we'll get started. Okay. Okay, and then you all can see the slideshow now?
Yeah, all good.
Okay, thank you. All right, so we can jump right in. So general information. So the rent stabilization actually we here at the Office of Rent Stabilization determine the maximum rent increase allowance each year. So that is determined by an equation. So it is the CPIU plus 3% or a flat 6%. So whichever is lower. So each year we'll publish that percentage increase, and that increase is valid from July 1st to June 30th of the following year. So for example, this year, the CPIU is 2.7. 2.7 plus 3% is 5.7. Since 5.7 is less than 6%, that means that the maximum rent increase allowance for this year, so from July 1st until June 30th of 2026, is 5.7%. So not everyone who is a renter in Montgomery County not every unit falls under rent stabilization within Montgomery County. The general rule of thumb is that unless otherwise exempt, and we have a slide about the exemptions, all county licensed residential rental units that are at least 23 years old are rent stabilized under county law. So we define a unit as being 23 years old on January 1st of the 23rd year after the property's year built date on the state's SSTAT website. So for example, if you go to the state's SSTAT website and type in your address and the year built date comes back as 2002, your unit became rent stabilized as of January 1st of this year. So for rent stabilized units, increases are only permitted at the time of a new lease or at a lease renewal. There are no mid-lease increases. If you sign a multi-year lease and you are in a rent stabilized unit, that rent must remain the same for the entirety of the lease term. So that means that, say you live in a unit for a year, if you're paying $2,000, you get an increase, it's, $2,050. And they give you a 2-year renewal option. If you decide, hey, I want to stay for 2 years, that means your rent for the next 2 years is $2,050. They're not allowed to increase your rent after that first year. Like all rent increases, the increase must be delivered in writing or in writing through U.S. mail or in person with a signed receipt, and at least 90 days before the effective date of the increase. The last one I want to touch on is that this is important to know that if this is a big change, especially with rent stabilization, if you live in a property that has been designated as troubled or at risk, your landlord is not allowed to increase the rent by any amount until they have that designation removed. And I know we have quotes speaking up in a little bit as well, so I'm sure they will touch on that. And then the last concept is the concept of banked rent or banked amount. So just because there is a maximum increase doesn't necessarily mean that your landlord has to increase your rent all the way up to the maximum. You know, say, for example, you and your landlord have a good relationship. Instead of increasing it 5.7%, he's only going to increase it 5%. Whatever that dollar amount that he decides not to use, he is allowed to save or bank for future increases. There is a limit to how much of a bank rent they can add on to your rent increase. And that's just to ensure that the landlord is not saving rent for however many years and then implementing all that banked rent on one tenant at the same time. So again, moving quickly. So we talked about, I mentioned that there are certain exemptions.
Sorry, Sharon, sorry to interrupt you. I have a question. Could you go back to last?
Of course.
For the, I know this has come up before, but for like clarity for everyone, the rule about troubled or at-risk properties not being able to increase the rent, does that only apply to properties that were already under rent stabilization?
Yes, so it applies to rent stabilized units.
Okay, so if you are in a non-rent stabilized unit and it is a troubled property, they're still allowed to increase the rent without caps.
As of right now, yes.
Okay, thank you.
Yes, yes. Thank you for pointing that out. So here we have exemptions. As I mentioned, not every rental unit in Montgomery County will be rent stabilized. So we have a full list of exemptions here. I won't go through all of them, but I wanted to touch on a few. The main one being here at the last one on the second column. So rental units located in Gaithersburg, Rockville, Tacoma Park, Barnesville, and Laytonsville are exempt from Montgomery County's rent stabilization because those are all of those locations have their own independent municipalities. So they have their own housing rules and regulations. So if you live in one of those areas, you would need to contact them about their specific housing code and regulation. The other one I wanted to point out before we move on, just keeping time in mind, would be the second on the first bullet, on the first column. So a unit owned by a natural person or the trust of a decedent who owns 2 or fewer units within the county. So this more applies to people who live, maybe have a smaller mom and pop landlord. It's an individual person. So this would be, for example, if, say, I'm Sharon Wilkerson, the person, I own my own home. I also own one condo that I rent out. Because that is fewer than 2, and that condo is in my name as Sharon Wilkerson, the person, that condo unit is exempt from rent stabilization. However, if I decide, for whatever reason, I want to do SW Properties LLC and then transfer ownership from Sharon Wilkerson, the person, to SW Properties LLC, that property is no longer owned by a natural person. It's owned by a business entity. And so that means the unit falls under rent stabilization. So again, this is not something that's, you might have to do a little bit of research, looking on the tax websites, eProperty, to see who the property is actually registered to in those cases. So we have just 2 more slides. So rent stabilization also limits the type of fees and the amount charged for rent stabilized units. So some of these fees are allowed an annual increase based on the CPIU. We will publish those increases each year. So there are certain exceptions. Landlords may charge a fee for optional services that a tenant chooses to enroll into. So these can be things, for whether it's pool pass, some of the newer units have a pet spa or a dog park or things like that. These are services that are extra that tenants choose to opt into. An optional service cannot include anything that impacts the entire community, and it cannot apply to any services required to ensure unit access, maintenance, or lease compliance. So examples of that would be um, just unit access would be some of the units have transitioned from the traditional lock and key into a fob, and as such have begun charging a fob or technology fee in addition to the rent. That is no longer permitted for rent stabilized units, just off the basis of you cannot charge a tenant to access a unit for which they're already paying rent for. An example of lease compliance would be that there needs to be an option to pay rent that does not include a fee. Oftentimes we can pay our rent online, and that sometimes comes with like a $2 or $3 convenience fee. There has to be an option that doesn't include a fee. That may just be walking to the leasing office when it's open and giving them the money order or check and getting a paper receipt. It may not be convenient, but it is available and it is free. So those are things to keep in mind. And again, at the end here, units exempt from rent stabilization are not required to adhere to the fee limitations. And so here, this is just a list of the current fees that fee limitations for regulated units. I won't go through all of them, but you'll see the ones that have an asterisk, such as the pet fee, the lockout fee, and the motor and the parking fee. Those are the ones that are allowed an annual increase by the CPIU. So you'll see that the lockout fee previously was $25 last year. It went up by 2.7%. So now it's 25.67. And again, these are the maximums that a landlord is allowed to charge. Just because they can increase doesn't mean that they will increase all the way. So that is the end of my presentation. Again, thank you all for having me here. If you have any questions, or if you feel like you may be experiencing a violation or anything, please call us through MC 311. They'll connect you to one of our program specialists. They're really great, and they'll help you take care of whatever you need. So thank you all for your time.
Sharon,
Yes.
can I just ask that each of the panelists, starting with you, since you're the first, can you distinguish your program and how someone should contact you from, say, Alta, Code, or Consumer Protection? So I'm a tenant. Why do I contact rent stabilization as opposed to Alta?
Oh, okay. So Ulta, and again, Nicole, please, if I misspeak, please jump in. We deal with everything related specifically to rent increases. Whereas like if you had an issue with your lease or an issue with your landlord directly, that would be something that you go to Ulta. So if it's something directly related to your rent increase and also a fee, then you can reach out to us.
Thank you, Sharon. Couple questions in the chat, but first I wanted to ask, can you just speak a little bit about, so if like someone was listening tonight and they're like, okay, I think I'm being charged this fee that I saw wasn't on there, or I was
Mhm.
charged this rate, and they call you guys, what kind of what does the process look like? Like, what will your investigators do? What does that look like once someone calls your office with a complaint?
So as of right now, we don't have like a direct complaint like system yet where you can just contact us directly and it'll bounce to one of us. You will have to go through MC 311. And so then once you're connected to a program specialist, they'll reach out to you, they'll listen to your problem, they'll listen to your issue. And so it may be, I have a question, this increase is incorrect. They'll take a look at the documents that you have, and dependent upon what they see, they may go to the landlord to, try to reach out to them to rectify the situation. And and then go from there.
Okay, thank you.
Yeah.
Question in the chat. What are the limitations on how much of the banked amount a landlord can apply to someone's rent?
Oh, yes, no problem. So the total maximum increase a landlord can take on your rent when including the banked amount is 10%. So I wish I was able to write it out. So it would be your total increase would be your current rent plus the rental increase allowance plus any banked amount. However, that increase may be no more than 10% of the current rent being charged. So that's the most simple way is to say that if they're including the banked amount, the maximum increase is 10% of your current rent. That's
Okay.
the easiest way. But what I just said is the more technical way to think about it.
Sure.
Mhm.
And on that same note, someone else asked, and I can say a little bit, how do we bank the amount? So that would be for the landlord, and that would be by them not charging the full for example, this year, instead of charging 5.7, which is a maximum, they only charge 3. Now they get to bank 2.7.
Yeah. So, and the key here would be it would be the dollar amount. So it wouldn't be the percentage. So the 5.7% increase would have been $60, but the 5% increase would have been $50. And you're not banking that 0.7%, you would be banking that 10% per se. So that would be added. And the way the landlords keep track of that is in using the housing portal that we have, that the county has put out, and that we're requiring all landlords to register their units on, whether they're rent stabilized or not. And the system's actually set up that it'll keep track of the banked amount for them.
Okay, great.
Mhm.
I don't know if this is more for you or if this is more for Ulta, but someone's saying like if they weren't offered a 2-year lease, I'm not sure if their building's stabilized or not, but would that generally go to Ulta or would that be ORS if it was a stabilized
It
building?
would go to Ulta.
Okay, thank you, Nicole. Right now I don't think I'm seeing any other questions for you, Sharon. But to the audience, like, please feel free to keep putting them into the chat as we go through the next speakers if you think of another question. Thank you, Sharon, for the presentation. Appreciate that.
Thank you all.
There was one question
Oh.
that I answered, and now I'm just like, oh, I should double check. If a tenant is offered a 2-year lease, but they chose to sign the 1-year lease option, could the landlord raise the rent when that lease expires in a year?
After the year, after the 12 months,
Yes.
Okay.
as long as they're not on a troubled or at risk list
Yes.
under rent stabilization, yes, they can.
Great.
Okay, now we'll go to our next special guest, which is Nicole Cachavanos, who's a manager at the Office of Landlord Tenant Affairs. You'll hear us abbreviate by saying ULTA. Thank you, Nicole. Same thing. You've been here before. We love having you here to answer all our questions. Would you mind just talking a little bit about what your office does, what kind of services you offer, and how people can get in touch with you all?
Absolutely. Thank you, Emily. Thank you, everybody, for being here and giving us the opportunity to share information to the public regarding our services. Nicole Cachavanos, I'm the manager of the Office of Landlord Tenant Affairs. I'll speak a little bit about our office, the services we provide, how you can get access to those services, and how we work in cooperation and collaboration with the Office of Rent Stabilization, Code Enforcement, the Office of Consumer Protection, and Fair Housing. And after that, I plan on talking on 2 legal issues that have been coming up recently. And I think it's important that tenants are aware of those fact patterns, what their rights and obligations are. And that includes breaches of leases and early termination. And it includes rent escrow, or when your landlord may have violations open with code enforcement, and what your options are if the maintenance issues aren't being addressed. So that's a summary of what I'm hoping to address in the next 10 minutes. So I'm keeping an eye on the clock. Feel free to, check in with me if you feel that I'm going over time. Okay, so the Office of Rent Stabilization the Office of Landlord Tenant Affairs predates the Office of Rent Stabilization. And our goal is to educate the public. We do that via our service requests, via phone calls, emails, and walk-ins. So anybody from the public, you can be a landlord, you can be a tenant, You can live anywhere in the country, but we address Montgomery County issues. You can either call us via 311 and one of the investigators in our office will give you a call back within 24 to 48 hours. And we do multiple attempts to reach you. You can email us at ulta.intake@montgomerycountymd.gov. I repeat, ulta.intake@montgomerycountymd.gov. If somebody can please, from Renters Alliance, put that in the chat. Thank you so much. If you send an email to us, we also respond within 24 or 48 hours. So feel free to take that option as well. And lastly, we do take walk-ins at our office. Our office is located at 1401 Rockville Pike. It's a big brown building. You take the elevator all the way up to the 4th floor, and you'll see DHCA. Our office hours are from 8:30 to 4:30. That said, we can't always guarantee that someone will be able to see you immediately. So if you're going to come to the office, we recommend that you come early, not on the later end, and that you come with time because sometimes there is a wait to be seen. But you will be seen by an investigator. All phone calls, all emails, all walk-ins are being addressed by investigators at Ulta. We have a total of 9 investigators in the office. Between all 9 investigators, we have over 80 years of work experience. So all the investigators are very well versed on the nuances of the law. And if there's any situation, because fact patterns can be very nuanced, if we don't have an immediate answer for you, we can and always do reach back out, do our research, and get back to you. As far as the educational component, we also have a number of resources that are available online. If you go to the DHCA website, I don't know if I can have access to show everybody, or maybe you can just put it on the chat. But at the top of the DHCA website, there is a tab that says Renters. It's the first tab. And if you go right underneath, there is a little sub-tab called Information for Tenants. And we've tried to break down the subject matters in a palatable way for tenants to be able to categorize different subject matters, whether you're in the stages of applying for a rental, whether you're in the stages of reviewing your lease, whether you're already paying rent and you have questions about payment. We have a section for security deposits, for maintenance, tenant services, as far as other resources that are available other than the Office of Landlord Tenant Affairs. We have notices, sample notices of what rent increases should look like if you want to compare your rent increase you received with the rent increase templates that we have. We have sample notices of terminating a lease. If you plan on ending your lease, you do not renew, or you plan on ending your lease early, we have sample notices. And we have a little bit of information regarding court eviction as well. In addition, we have a whole section regarding publications. We have multiple pamphlets there regarding how to prevent eviction, regarding ordinary wear and tear. So highly recommend that if you have time to go and look through our website, look at the materials. We have a landlord-tenant handbook, which we are in the process of updating. And we are also in the process of ensuring that it's accessible in all the working languages, first being Spanish, but we're also going to work in the next year to get them translated in Amharic and French and Korean and Mandarin and so forth. So that's the educational component. We always recommend, if you're a landlord or a tenant, I know everybody here is probably, most of you are tenants. If you have a concern prior to going to file a complaint with us, which is the next service we have, give us a call first, email us first, talk through the process, know what your rights and obligations are. Try, if you can, to come to an agreement with your landlord. If for some reason that's not viable, there's been contentious actions in the past, and you want to move forward and file a complaint, you can. But we always recommend that the first step is to reach out to us, contact the landlord, and then afterwards file a complaint with us. So moving to the second portion of our services, which is the complaint process. You can file a complaint online. That's the way we highly recommend that you do it. We always ask that you attach all relevant documentations to your complaint, so a copy of your lease. If you are contesting your ledger, for example, a copy of your ledger or any payments or copies of receipts. If it's a security deposit, any related documents to your security deposit, potentially photos of when you moved in versus when you moved out, everything that you attach on the onset to your complaint assists the investigator in the investigation. So you file a complaint with the Office of Landlord Tenant Affairs, ideally online, but you can always go in person and file a complaint physically in person as well. And we assign the cases to an investigator. The investigator then reaches out typically within the week of assignment, which could be anywhere from 7 days to about 15 days from when you filed a complaint. And the investigator's role is a neutral role. It is not an advocate for either party. They are neutral. They reach out to both parties. They speak with both parties. They collect documents from both parties. The goal, as the protocol is always to reach out to the complainant first, since it's the complainant that filed. But there are times where the investigator will reach out to both parties at the same time, or if they've tried to reach out to the complainant and can't get a hold of them, they'll reach out to the landlord to start collecting documents and so forth. The investigator then reads through everything. They set expectations with the complainant regarding the scope and the parameters of our investigation. Many times complainants will have 5 different issues that they want to address, but some of them are just simply not within our scope, or we don't have the capacity or ability to address. So it's ideal that there's some kind of communication on the onset with your investigator so you know the parameters of your investigation. In situations where it's very clear cut that there is a violation, there is no dispute regarding the facts, both parties agree to the fact. It's just a matter of whether there's a violation or not. The investigator can inform the parties, yes, there's a violation, no, there's not a violation. If there is a violation, they will indicate to the individual, in this case, if it's a tenant, they will indicate to the landlord that they have to be in compliance, what they need to do to be in compliance, and provide a time frame. If they don't meet that, then the investigator has the authority to issue a citation immediately. Our citations consist of $500 each, and it's essentially a penalty for not aligning yourself with compliance. And in this situation, hypothetically, if you have a tenant filing, if the landlord doesn't pay the citation, doesn't comply with the determination of the investigator, then we send it to our Office of Counsel Attorneys, and it can go to court. And then we present it in front of a judge, and the judge will typically require an abatement, which means compliance with our decision. Now, in situations, which is the majority of the cases, where things are not black and white, where there's hearsay, where there's missing documents, the next step of what we do, which is the majority of the situations, is we try to conciliate. We try to get both parties to come to an agreement with a situation that they're both comfortable with. If that's fruitful, then we draft a template of a consent agreement. The consent agreements are very general agreements. We typically don't tailor them too much, but they say the basic of information. A complaint was filed, neither party is admitting guilt. In order to conclude this investigation, these are the terms of our agreement, and then they're both signed. And it's the responsibility of our office to ensure compliance of that consent agreement. If either party, whether it's the complainant or the respondent, signs a consent agreement and then doesn't comply, we will issue a citation for noncompliance, and we will move forward with district court filing in district court. Now, in a situation where we've tried to get both parties to the table, whether it's a physical table and in person, or whether it's via Zoom, or whether it's phone calls back and forth, and we cannot get the parties to come to an agreement, the next step is to present it to the Commission of Landlord Tenant Affairs. We have a commission that's composed of 15 volunteers, 5 tenant category commissioners, 5 landlord category commissioners, and 5 public at large commissioners. They meet on the first Tuesday of every month virtually, and that is the forum where ULTA investigators will present their case summaries for the ones that were not fruitful in the conciliation. Then the commission does a vote. They decide whether they're going to take jurisdiction or not. That is completely in their It's their sole decision-making autonomy to decide if they're going to take jurisdiction or not. If they do, then we schedule a hearing. The hearings are typically done via Zoom. They consist of 3 panel members for the commission. And the hearing is similar to a hearing to what would happen in district court. But it's, as I mentioned, it's done online, and our rules of court processes and evidence are much more relaxed, since we know that the majority of complainants are not represented and are not well versed with the legal process. The office does provide documentation for complainants who don't have attorneys, so they can inform themselves and prepare themselves for that hearing process on how to present exhibits. You know, if there's going to be an opening statement, what the questions are going to be like, if you have any witnesses and closing statements and so forth. The decision of the commission, it has the same exact weight as a decision of a district court judge. Decisions and order are issued, and then the parties must comply to the decision and order. If they do not, then they're subject to a citation, and then they are subject to a hearing in district court. All our hearings are appealable, just like district court cases. If you want to appeal, then you have to post the bond for the decision order amount, and then you appeal to the circuit court, and it moves forward in that process.
Nicole,
So
if I
that's
could throw in real quick at this point, just
Mhm.
talking about representation. The Renters Alliance is working closely with the Maryland Legal Services Corporation in the Access to Counsel in Evictions program. So if you find yourself going through ULTA and COLTA and facing eviction, please be in contact with us, because we can make sure that we connect you to legal services, especially if you're a low-income tenant. We think everybody who goes to court facing eviction should be represented by a lawyer, and we can help arrange that. Thanks, Nicole.
You're welcome. So that is a summary of the services we provide, and our processes. Two subject matters that I wanted to address today. One of them is what to do in situations where you're having a maintenance issue. You've addressed it with you've addressed it with your property manager, your landlord. It's not fixed. You addressed it with code enforcement, and there is a notice issued, but the landlord is still not complying, and your maintenance issue persists. Code enforcement, I believe, will be speaking later, so they will talk to you in detail about what their process. But if you're at that point where you've already gone through code enforcement, the maintenance issues persist, what avenues are available to you? The first avenue, which is the one that we typically recommend, and I'm sure you've heard about it in the Renters Alliance forum, is rent escrow. It is an ideal forum for many reasons, because when you go to the district court, and you can go to the second floor of the district court, there's a help center where there are free attorneys. They can show you the forms, they can help you fill it out, they can help you prepare. In addition, you can call them. They have a hotline that's open, I think, from 8:30 in the morning until 8 p.m., and they can walk you through it over the phone. If somebody from Renters Alliance can provide that number on the chat, that'd be great. When you follow rent escrow, the key thing to know is you cannot stop paying rent to your landlord until you've had your date in court, your initial date in court for rent escrow, and the judge authorizes you to do that. I've seen on many, many, many occasions that tenants on their own will withhold rent because the landlord isn't satisfying their maintenance requirements. You should not do that. So go to court, you follow rent escrow, you have an initial hearing date, and at that hearing date, you should be prepared with your documents to show what your maintenance issues are, whether they're photographs, whether they're medical reports, the notice of violations from code enforcement, etc. At that first hearing, the judge will say if you can move forward and if you should be paying your rent moving forward into a rent escrow account. One of the great things about filing rent escrow in district court is, one, that if you're prepared with the documentation, the judges are very used to tenants representing themselves. Two, we have a number of organizations like Maryland's Legal Aid and CASA that work on rent escrow cases that can potentially support you if you can't if if you don't feel comfortable and if you qualify for their services. But most importantly is that if you're successful and you do have a valid claim, you can ask the judge to reduce your rent during the time period that you were living in the property with a reduction of services as a result of the maintenance issues. You can ask them to eliminate the rent during that time period. You can ask them to terminate your lease early. You have a lot more options available to you. So, especially in situations of severe issues, we highly recommend rent escrow. And the main message is don't stop paying your rent until the judge has told you you can do it. And it may seem intimidating, but there are attorneys there that will walk you through their process, will fill out the forms with you to ensure that you're doing things properly. Now, the law also provides for what is called a repair and deduct. It's something that DHCA is involved in, but it doesn't provide you as many avenues of relief as a rent escrow situation in court. And the main thing that you need to take away out of repair and deduct is that one, you can only move forward with the repair and deduct, which means that the tenant repairs out of their own pocket, and then it is deducted from their rent. That's why it's called repair and deduct. In order to do that, one, code enforcement had to have issued notice of violations and the landlord has not complied. And two, once that occurs, you have to, as a tenant, contact the Office of Landlord-Tenant Affairs and say, I want permission. I want authority to move forward with repair and deduct. We then do an assessment. And once the DHCA has authorized, then you can move forward. And there's a number of steps that need to be taken. There's a special contractors off of a list that you have to hire. And essentially, you can make the repair yourself and it will be deducted from your rent. However, unlike rent escrow, you can't get a rent reduction and you can't get out of your lease or no payment of rent during that time period. So depending on what your situation is, how severe the situation is, how much potentially you would have to pay out of pocket and how much you can afford to pay out of pocket, you'd have to do an assessment of what works best for you. If you're trying to decide and you're not sure what's best works for you, you can always give us a call and one of our investigators can talk you through it.
Nicole, if I could just jump in on that, that particular provision is something the Renters Alliance strongly supported and proposed and finally got it enacted. But it was designed to handle those small things that tenants just couldn't get a landlord to fix, like a running toilet or something. And so one other aspect of it is that the repair and deduct can only be a deduction up to 1 month's rent. So it's
That
for
is
those
correct.
things that are limited in expense to 1 month's rent. But for many cases, it's, with working with DHCA, and again, to underscore what Nicole just said, you have to get a citation and you have to get written permission from DHCA to go forward with repair and deduct. Don't do it unilaterally. You'll be responsible for the rent. But it can be for those repairs that are up to 1 month's rent through that process.
And it's a deduction of your rent. It is not a reimbursement for the expenses. Thank you, Matt. I know I'm short on time, so the next thing I want to talk about, I'll make it brief, has to do with early termination. If anybody on this call, or if you know anybody who wants to terminate their lease early, please call our office before you do that. Because it's important, one, that you notify correctly to the landlord, that you do it in writing within the required time frame. And two, there are potential different liabilities if you terminate early because of one of the outlined reasons that you can terminate and only provide 30 days notice versus if you don't. There are a list of reasons that you can terminate early with only 30 days notice. If you terminate for any other reason, for example, if you decide you want to purchase a property and you're moving out of your rental, or you decided you just want to move, not necessarily because you're not employed and you changed job, but you just want another space or another environment. The landlord always has an obligation to mitigate damages. So they have an obligation to post immediately, to show the unit, to try to re-rent it immediately. But if you have 6 months left of your lease, and if the landlord re-rents that unit, let's say a month or two later, and the person that moves in for some reason defaults within those first 5 months, if they rent it out a month later, and within the first 5 months, that person defaults, you are secondarily liable. And I think a lot of tenants aren't aware of that. So it's important when you make your decision to terminate a lease early that you are very clear under what category you fall in and what your liability exposure is before you decide and terminate a lease early. So highly encourage anybody. I know there's a lot more details I can provide, but I don't have enough time. That if you want to talk through a potential early termination, contact our office and we can do that in detail with you.
Thank you, Nicole. That was a great overview. Couple questions in the chat. You already touched on this, but maybe if you could just repeat it. What is the next step if Ulta has closed a case when there has not been a conciliation process or consent agreement? So I think maybe they're asking about the referral to the COLTA that
The
was
commission.
that's
So what will happen is that the investigator will draft a case summary. I review the case summary. It's presented at the next commission meeting, which is held virtually on the first Tuesday of every month at 6:30 p.m. If you go on our website, we have links. Anybody can attend and can watch and see what that process is like. The investigator presents the case summary, meaning they read through it. The commission can ask questions, clarifying questions, and then they take a vote to decide if they're going to take jurisdiction. If the majority vote says yes, they're going to take jurisdiction, then we schedule for a hearing. After the hearing is scheduled, all parties receive notices and they receive a summon to attend the hearing virtually.
understood. Okay. On similar,
Hey.
someone. Oh,
Go
Oops.
ahead,
oh,
Emily.
sorry, Pat.
That's okay.
Someone else had a question. What are some reasons why the commission would not take jurisdiction to hear a case?
I can't speak for the commission. There are two avenues on when a case can be presented. A case can be presented with a recommendation for a dismissal. If a case is presented for a recommendation of dismissal because the investigator, with my approval and with my overview, has found through that the investigation that there is no reasonable grounds to believe that there's been a violation of Chapter 29 of the Montgomery County law, then the commission can either uphold the dismissal, which means it's being dismissed, or they can send it back to the Office of Landlord Tenant Affairs for further investigation. So similar to appeal, they would send it back and say, we want you to look into this matter and this matter a little bit closer. In the alternative, if an investigator presents it for a recommendation of a hearing, there have been times, it's not often, the majority of times they accept it. There have been times where they don't. They do not give a reason. It's just a vote. It's a yes or no vote. You can you can come to conclusions as to why. There could be multiple reasons why, if the commission believes that this is something that would be better addressed in court versus the commission. If it's something that they're not ready for one reason or another to create precedents on, that could be a reason. If I can't speak for them and they don't say why, but those are just typical situations why any judicial body would decide not to take a case.
Okay. And then maybe this will be our last one for now. Could you just lightly touch, you were talking about early termination. Could you just speak briefly on constructive eviction? Someone in the chat asked if you could touch on that.
Sure. Constructive eviction is a concept which essentially means that the landlord creates a set of circumstances which leads to an eviction. We don't have much precedent regarding constructive eviction. During the time of COVID, where we would see exorbitant amount of rent increases of 100%, 90% increase, our office would hold the position that an increase of such a high amount is equivalent to a constructive eviction. But it's something that there isn't a lot of precedent on, and that is challenging to address, but we always welcome it.
Okay. That's looks like all the questions for Nicole. Feel free to keep putting them in the chat. Before I hand it over to Jackie to
Can I
introduce.
just can
Oh,
I
yeah,
just
go ahead.
ask a question to Nicole? Someone in it has a question about paying their rent late month to month, and they want to know, can the owner of the property ask them to vacate for being late with their rent all the time? Is that a reason to ask them to vacate the property?
So there's a difference between asking someone to vacate versus providing a notice of non-renewal versus filing in court, right? The landlord can ask you to vacate, but you have no obligation to do it. And verbally asking doesn't trigger anything. Now, there are laws that say that technically a rent is not late, even though after the first it's late, you can't incur penalty fee, you can't incur fees, or fees are limited to a certain amount. And failure to pay rent action, where the landlord would file in order to get possession, can't happen until they provide you a formal notice with a summary ejectment, and after the 10th or 11th day. Please, it's been a while ago, so please correct me. At that point, they can, once they've done that, then they can move forward with the court process and move forward with a potential request to the court for possession of the property for not paying rent. Some landlords have tried to be creative and say that failure to pay rent is a breach of lease. But we always recommend tenants to be timely with their rental payments. And if you have a history of not paying on time, and if someone can choose not to renew your lease because if you have a history of not paying on time.
Let me throw in some things, and Nicole, let's reverse this. Tell me if
Sure.
I'm wrong.
Yeah.
Here's the 4 ways you can be evicted. First is failure to pay rent. You don't pay your rent, they can give you a 10-day notice of summary ejectment saying that they're going to file in 10 days for your failure to pay rent. So you can be evicted if you don't pay your rent. The second thing is breach of lease. So that's if you've violated the terms of the lease. And it has to be usually something substantial. If that happens, the landlord could say you're late all the time, or you're making too much noise and we've told you multiple times to stop, or you've committed crimes or some other violation of community norms, especially those that are written in the lease that you've signed. So breach of lease. The third is, Nicole was referring to, tenant holding over, which is that any landlord at any time could say, we want you out at the end of your lease term. So they have to do so with 60 days notice, but at the end of their lease, and they don't have to provide a reason. We're fighting that right now. We're trying to get good cause eviction passed so that they'll be required to provide a substantial reason not to renew your lease. But right now in the state of Maryland, with 60 days notice, they could say, we're not going to renew the lease, and they don't have to say why. But they have to give that 60 days. And if you stay a day longer, then your status is called tenant holding over, and they could sue for eviction on that basis. And the last is called wrongful detainer, or that would be for people who are squatting, who have no right to be in the apartment or property in the first place. So those are the 4 ways. The most common is failure to pay rent, obviously. Keep
One
that.
thing I just want to comment, if anybody knows of anybody who's been a victim of an unlawful eviction, meaning that a landlord has changed the locks to put anybody's belongings out without going through the court process, call us immediately and notify us immediately, please, because we will take action on that, and it will be immediate.
Thank you, Nicole. I just had one more question. Actually, it's back for Sharon, about the banking again. I believe it's a landlord question. Where do they go about like banking them out? I think they're asking about the system. How do they access that?
So there's the housing portal that is, if you go to the DHCA website, there should be, right next to the renter or landlords tabs, there should be a housing portal one. And so landlords are required, whether they're rent stabilized or not, to register each lease for all their units. And so say you have a unit, you have, unit 101, and the rent was $220 one year. The next year, the lease is up, they sign a renewal, you add that new lease again. If you decide to take the less increase, that bank, there's a 10%, there's a $10 banked amount that you decide to keep. The third year comes around, it will have that the system itself will keep track of the banked amount for the landlord, and will also the system is set up to limit the landlord from inputting amounts over what they're allowed.
Okay, thank you,
Mhm.
Sharon. Not seeing any more questions for Nicole. Thank you, Nicole, for providing all of that. And for the four evictions we just talked about, I put a link in the chat that like outlines the four different types and the process between like filing in court, scheduling the hearing, and all the steps. Um, Thank you guys both so much. I'm gonna pass the mic to Jackie to introduce our, oh, Nicole.
Just one more thing that I wanted to tell all the viewers today. If you're not well versed with the county and our services, whether it's the Office of Rent Stabilization, Code Enforcement, the Office of Consumer Protection, the Office of Human Rights that does fair housing and does discrimination issues, I just wanted to let you know that if it comes to the wrong office, we do work within ourselves to make sure that there's a proper referral. So many times the Office of Rent Stabilization will get a case and it should be Ulta, and they'll close it on their end and they'll refer it to us. Or we get something that should be code enforcement. We'll close it on end, we'll notify the tenant, we're sending it to code enforcement. You'll now hear about the Office of Consumer Protection and how we work together and how we refer things back and forth. And the the Office of Landlord Tenant Affairs also works closely with the Office of Human Rights and does referrals. So while it's important that you educate yourself, in an ideal world, you know exactly what each office does. If for some reason you file a complaint and it's supposed to go somewhere else, we will make sure to close at our end and do a referral to the other entity and let you know that it's been transferred.
Thank you, Nicole.
Not a problem.
Yeah,
Thank
let
you.
me pass the mic to Jackie to introduce our next special guest. Thank you both again.
Mhm.
Good evening, everyone. I'm Jackie. I'm the Senior Outreach Coordinator for the Renters Alliance. I'm going to go ahead and introduce our next guest, who is Austin McNamara, who's going to speak to us about the work that he does with the housing code enforcement. Austin, go ahead and take us away.
Great, thank you. Good evening, everybody. I'm Austin McNamara. Um, like she said, I work with the Department of Housing and the Code Enforcement Division. I'm a project manager for the multifamily unit, and the primary thing we do is we inspect apartments. We inspect units that are rented. So last fiscal year, we inspected 350 properties. That's over 15,000 units. With that information, as you've heard a little bit about from the other presenters, we compile that into the troubled property or at-risk property lists, which then gets the action you see from the other presenters. Essentially, we are the eyes for the housing department. We're the inspectors that go out, and if you have an issue, we're the ones that will come to your house and take a look, whether it's a complaint-driven inspection or, like I said, these required inspections that we do every year. So like I said, we did 350 properties last year. We have more than 300 properties scheduled for this year. So we're going to be out in the community. I'm sure that some of you will see us in the next few months. So, beyond just like I said, those kind of inspections, our main focus is just to make sure that everyone in the county has a safe place to live. That's our ultimate goal. And that can be through, and we do offer these mandatory inspections. That doesn't require any kind of action from the community. That's just something that we are mandated to do. If that does happen in your complex or your building, your property manager will notify you of the upcoming event. Depending on the level of inspection, we will do between 25% of the units or up to 100% of the units, depending on previous inspections. Troubled properties, which is broken down through an algorithm of severity of violations, number of violations, percentages of the property. That all gets broken down, and each property is given a score. Could be troubled, at risk, or compliant. Troubled properties are inspected every year. At risk properties, they might get a little bit of a break, but most buildings want to come off of that list for the reasons that we've talked about already here. And they have the opportunity to get back on the list for another inspection after correcting the issues that were found originally. Compliant properties obviously don't have much of a reason to want a more recent or more, another inspection quite as soon, but they are still inspected every 3 years at a minimum. To get a hold of us, like I said, these mandated inspections are just county mandated. We do that on a rotating schedule, but if you have an issue with your unit or, some of the things we've already talked about, to initiate landlord-tenant affairs investigations, a lot of times code enforcement will document the violation, give the property management time to correct that violation. If they don't, that's a lot of then goes to landlord-tenant affairs because the property management has not kept up their end of the lease. But for these complaint-driven inspections, 311 is the best way to get a hold of us. So you can just dial 311 from anywhere in the county. That way you get a service request number that can be tracked through the system. So anytime you call 311 with that number, they can give you an update. If you talk to anyone in the department or anyone in the code enforcement division, we can monitor, with those numbers, the service request numbers. There's also an online option on 311. It's just Montgomery County 311. It's on our main website. You can fill out a form. The same process will occur. You'll get a service request number so you can follow up with your request through the entire process. We do have a informational email, dhca.code@montgomerycountymd.gov. That is more, like I said, informational, seeing if what you're experiencing might be a code violation, just finding out about the process. And definitely someone will get back to you, whether it be electronically or with a phone call. But like I said, for complaints or for service requests, I definitely recommend going through the 311 process, just because that is the way that you can, you have that information to follow it through the system. No matter what the outcome is, you can use that service request number to make sure that you're up to date with everything, even if you don't have direct access to the inspector that's assigned. So yeah, that, and like I said, anytime we get a call, we will make that inspection, whether that be for something, relatively minor. It could be in your unit, in the common areas, exteriors, anything maintenance related. That's the primary thrust of our code that we enforce.
So Austin,
Yeah.
I think clearly those things might be like mold and vermin,
Correct.
mice, bread bugs, appliances that are broken. What else are the sort of top things that you see?
So the rule of thumb is if it's provided with the unit when you move in, it has to be kept in good condition and maintained and work. So like you said, a lot of times we do get calls concerned about mold, vermin. Obviously, those are some of the most obvious and concerning things that people come across. But even things like, if a crack develops in your wall, if the paint starts to flake, something of those, something even relatively minor like that, those are things that we go out and will inspect and require corrections. So the things that you were talking about kind of go back to the troubled property or at-risk properties. The vermin, the mold, plumbing leaks, things of that nature. Those are the more extreme and more heavily weighted violations in those lists in that algorithm that I spoke about. But we still take into account the flaking paint, the crack in the wall, the carpet that becomes worn and might be a trip hazard, things of that nature. Elevators, we don't necessarily maintain or issue the certificates for elevators, but if an elevator is not working, that's something that we go out and enforce. So literally anything in the building that is supposed to be maintained, and if it's not, we will go out there and take a look at it and require correction or guide you in the right direction.
There's a new mold law that took effect this year. How is code enforcement working to implement and enforce that now with what you're seeing when you go out and make inspections for mold complaints?
Sure. So that is something that we have seen an uptick in, and really mold is treated. The system for enforcing that is really just like any other complaint. We go out, we do an inspection, we verify the problem, and there are mandated corrections to fix the mold problem. So actually the way the code that we enforce is that typically mold is caused by moisture. And so the code actually says that the property management has to find the source, correct the problem, as well as, what might be the visible mold in the unit. So it's not just we see a spot of mold and ask them to paint over it. It's, they have to find the cause, what's causing the mold, repair that, whether it be a leak, whether it be a faulty bathroom exhaust fan, whatever the case may be that's creating that moisture, as well as fixing the damage that was created by the mold.
Someone was asking how closely you work with HOC for code enforcement at all, or is it just two separate things, or do you have any kind of collaboration at all?
So HOC
For code enforcement.
Right. So I'm sorry. Is the question, we don't make inspections together, I guess,
No.
might be the question. So HOC obviously works with the county as far as, housing, but as far as code enforcement goes, we don't have much contact with the HOC inspectors or employees over there in the code enforcement sense. Our inspections are done independently. So HOC properties are just as responsible for maintaining their properties as anyone else in the county.
I can say, just to throw in, that in our discussions with the director, Scott Bruton, DHCA director Scott Bruton, that there is a new collaboration between code enforcement and HOC when HOC inspectors, which are separate from Montgomery County code enforcement, determine that a property or a apartment has failed. Their inspection standards are based on what the United States Department of Housing and Urban Development standards are. So it's a different set of standards.
Mhm.
But if somebody finds that their inspections have failed from the HOC inspectors and they are facing losing their home, there is a new collaboration between DHCA and HOC to send DHCA code inspectors to make sure that the landlord makes the fix so that the tenant doesn't have to move, because DHCA inspectors do have the power of enforcement. HOC inspectors do not.
Yeah, that's correct. And thank you for the clarification. Our inspections are independent, but we do collaborate with them, in other areas. Just code enforcement, our inspections and our enforcement process does not rely on HOC inspections or anything of that nature.
Question for you, Austin. What does violation unfounded mean? They said that it's used often for my property and there isn't any visibility into what the landlord has told code enforcement. So this is when they look at the e-properties and they see that it's been unfounded.
So a violation unfounded means that the inspector was not able to identify a violation that we have a code to enforce, basically. So just as an example, I was just in a property yesterday where I was reported that there was a plumbing issue, but upon inspection, the plumbing issue was intermittent, and I was not able to recreate the problem that was being described. And through conversation, it seems like the problem is reoccurring, but happens perhaps every 3, 4, even 6 months between instances. So just when I was there, I wasn't able to recreate it. So I couldn't then ask the property management to fix something because I don't have a clear course of action for them to follow. So that's what violation unfounded means. Sorry, was there a second part to the question? Okay.
Yeah, they say it was just because it's not visible. They were just trying to figure out what that means. And then one final question to you is: there's a tenant.
Yeah.
Go ahead.
I was just going to say I remembered what I wanted to say. As far as what the landlord says, I think that was the second part that I was thinking of. Everything that code enforcement does is based on the inspector's observations. So obviously we have to work with the property management as well as the tenant to gain access and to get these corrections made. But at no point does a tenant's statements or a property manager's statements impact our enforcement process. Unless our inspectors can observe the violation and pinpoint a course of action to correct the violation. Otherwise, the statements of other parties just kind of get us to the building to make our inspection.
Okay. And just one final question for you that just came in. Does code enforcement ever consider how effective and or responsible particular exterminators are?
So with exterminators, the way that we enforce that is obviously we require that the extermination takes place. But we do not, similarly to the last question, we don't end our inspections there. We don't end our enforcement there. We have to make re-inspections and verify that the extermination process is working. So we do require extermination records. We do require that the exterminators go in and do their work, but then we follow up and make our own observations about the state of the extermination or the state of the infestation after a certain amount of time.
Okay. Thank you so much, Austin. In the interest of time, I'm going to move us along, and I would like to introduce to you all Patricia Vitale with the Office of Consumer Protection. She's going to speak briefly about the work that the office has been doing since it's been implemented and to answer any questions we may have quickly. Patricia, you can take us away and just introduce yourself and talk to us about the Office of Consumer Protection.
Sure. Hi, I'm Patty Vitale, and the Office of Consumer Protection, as you probably know, has a new charge as of this summer. The county council passed a bill that will allow us to handle certain narrow categories of landlord-tenant issues, and they're really related to deceptive trade practices, which is what our office investigates. The typical cases that we have been getting for years are towing complaints if people feel that their car was wrongly towed from a lot. Home improvement cases, we have a lot of contractors out there that, that generate complaints through people that hire them. Retail establishments, stores, people have issues when they go into stores, and also auto repairs and sales. So that's the bulk of what we do. But the council passed this bill so that we can handle deceptive trade practices by landlords. And so far, right now, we have 10 cases open. So we're pursuing those to see how we can handle these in the long run and what the resolution is going to be. 8 of those cases are against the same building. And the complaints are basically, we were promised certain amenities. In some cases, they were just advertised. In some cases, they're written into the lease, and then the amenities go away. They're removed. A pool is taken away so that they can put in more units. They said there was going to be, a dishwasher in the unit, and now they're taking the dishwashers away, things like that. So these cases are new, they're early on, and our process is much like Ulta's process. We receive complaints online or we receive referrals from Ulta. We assign them to an investigator, and I can tell you our investigators have certain areas of expertise. They each have particular portfolios. We have an auto expert who handles the automobile cases, etc. So one of our investigators has done landlord-tenant work in his previous career, so he is handling all the landlord-tenant cases now. His name is Lee Glass. So he reaches out to the tenant, first of all, to find out what the story is and to try to get any documentation that's available that they have. And then he does reach out to the landlord to get a written response to the complaint from them. And we try to mediate these disputes. So it remains to be seen what kind of resolution we'll be able to bring about in these cases. Our office does, when there's a violation of law, we can issue citations. We like to try to resolve cases through conciliation, because when we write a citation, the citation is to the merchant or to the landlord, and they will have to pay a fine of $500 to $1,000. But that money does not go to the tenant or the consumer. That money goes to the county. So it's better for the tenant if we can resolve the issue and get the landlord to correct the issue or to compensate them somehow for that. So like I said, the law was just went into effect in July, so it's very early on, but we are getting cases. When DHCA has a case that they think is for our office that involves a deceptive trade practice, they'll forward that to us and we'll open a case. We do have we have a weekly meeting scheduled. Nicole and I meet with Investigator Glass once a week, so that we've got it on the calendar so that we can get together and discuss any pending cases that we have, any questions that we have for each other, as things develop with this new law. And if you want to reach out to us about something that's not landlord tenant related and you have a consumer complaint, we do have, you can call MC 311 and an investigator will call you back quickly. You can email our office at consumerprotection@montgomerycountymd.gov. We also do have walk-in hours Monday to Friday, 8:30 to 4 p.m. And we have 8 investigators. We'll be hiring a 9th investigator soon. And when you call on the phone or when you walk into our office, you will meet with an investigator. Let's see. I think that's all I needed to tell you about, unless you have any questions.
Any questions for Patty Vitale from Consumer Protection, Jackie, or anyone paying attention in the chat?
Someone just said,
I'm sorry, just to clarify, a tenant can walk in your office or do they have to go through Alta?
You
Can they
can
stop?
you can walk into our office. Yeah, I think it's better to call ahead first because this is because for landlord tenant issues, it's so new. I would say make sure you're going to the right place first. I don't want you to come to our office and to have us say, "Oh, you have to." That's for Alta because they're down Rockville Pike. We're in two different buildings. We're actually across from the district court in the council office building at
But
100
if assuming they are in the right place,
Sure.
you can help them um, right away, or do they have to go back and file with Alta? File with uh,
Consumer
No,
protection.
Yeah.
you can file directly with our office.
Okay.
And we try
Okay.
at all times, we try to be staffed so that we always have investigators in the office.
Thank you.
Mhm.
Great. We're running out of time here. We just want to wind up with a few other pieces of information. Do we have any other questions for Patty Vitale?
I see one in the chat and while we're on, I'm gonna look it up in our system. Someone said they sent something to us and they haven't heard back, which I'm gonna check on that for you.
Great. Then
You
let's
also had
quickly.
there was
Maybe
also
some-
a question about how the public, whether the resolution of cases is available to the public on these cases and how they can find out, or if
And how that data is managed, yeah.
How the data is managed. Everything filed with our office in all cases are public information, like anything filed with any government office. So if someone has a specific question about that, they can file a request under the Maryland Public Information Act. And there's a form on our website to do that. And we'll provide any information that we're able to provide, unless it's confidential, people's personal financial information, things like that.
Now, Patty, OCP does not have a similar e-properties kind of database that where you can track cases.
We just had. I have to look into that because we did have a search function on our website where you could look up certain merchants to see if anything had been filed against them, but it only showed cases with certain dispositions, things that were closed in a particular way. And we just had a big website change, and that search function may not be available at the moment.
Okay.
So I have to look into that. If you have a question, it's better to call or submit an MPIA request because the search function it didn't show everything when it was available, and I don't know if it's still there. I have to check.
All right. Well, we certainly appreciate the information that you provided to us this evening. You can tell Eric Friedman, the Director of Office of Consumer Protection, that we have the usual warning that we're going to invite you all back to go through the towing process when people are towed through predatory towing because it happens so often and tenants are incredibly impacted by predatory towing on their properties. And we know that the Office of Consumer Protection has a process for those complaints. So we'll get back to you for sure. We also appreciate your coordination with landlord tenant. We know this is a new law, but it's important that people find no wrong door when seeking services through the county, especially our tenants who are overwhelmed by the power of landlords and the threats to losing their homes. So quickly, let's go through just a reminder of what is out there. We've got the Office of Landlord and Tenant Affairs, which handles lease disputes and violations of your rights. We have the Office of Code Enforcement, which handles maintenance violations and code violations. We have the Office of Rent Stabilization, which handles increases in rent that may be legal or illegal depending on the rent stabilization law and whether or not it applies to your apartment community or not, and the fees associated with those increases and whether they're allowable or not, and whether your property comes under the rent stabilization law. And lastly, we have the Office of Consumer Protection, which now has a little bit of overlap into landlord-tenant enforcement of your rights having to do with deceptive business practices that your landlord may be involved in. We also want to talk a little bit about the Access to Counsel and Evictions program. Is that you, Jackie, or Emily?
Yeah, I just put the information in the chat. We touched on it earlier, but if you are facing eviction, the state has access to counsel and evictions program where you may qualify for a free attorney if you meet the income requirements. You can get in touch with them by calling 211 to do an intake, or you can call one of the providers directly, the two being CASA and Maryland Legal Aid. They always recommend that you get in touch with them as soon as possible. So, like the day you receive a court summons, um, they they'll talk to you about your case. They can possibly represent you. Even if they can't represent you, they can still give you legal advice about your case. Um, Please get in touch with them as soon as possible if you are facing eviction.
Quick announcement, October 8th, which will be our next Renter Town Hall, will actually be co-hosted, co-sponsored by MyMCM Media and broadcast live on their cable station, and will feature a forum of the upcoming candidates for county executive focused exclusively on renters' rights and affordable housing policy. It is the first and only of its kind for candidates running for county executive. And so we will provide everyone with more information about how to watch it on TV, and it will be a live broadcast. Also, I just want to add one more thing through Pat Beckham, our outreach coordinator. What do we ask people to do? Can't hear you, Pat.
Well, please vote. It's your duty. We need you to do it when your turn comes. Research who is out there running that can help renters and go vote. Secondly, I'd like to thank Carl who put in the chat to remind us that October the 1st is the last time you can apply for the tax credit. And I have put the email address in the chat. But please vote, people. That is our strength. It's our only weapon. So when your turn comes to vote, go vote.
And we will provide information as we do every year on the voting process, where you can vote, and all of that when Dr. Z from the Maryland Elections Commission of Montgomery County Elections Bureau comes to speak with us again. We will do that. But absolutely, please vote. And the Renters Alliance will be printing a whole new batch of I'm a Renter and I Vote button. So if you want one, email us and we'll be happy to send it to you. And we'll have them, of course, at our information tables. Let me say thank you to Nicole Catravanos, the manager of the Office of Landlord and Tenant Affairs, Sharon Wilkerson, a program manager with the Rent Stabilization Program, Patty Vitale, with the Office of Consumer Protection, Austin McNamara from Code Enforcement, and to all of our staff here at the Renters Alliance, thank you for joining us this evening.